plug some of the exciting stuff that's going on at the National Constitution Center. As many of you know, we have a crowdsourcing campaign to support our We the People podcast and also the Live at the NCC podcast, which will run the audio of our program today. And thanks to our friends at the John Templeton Foundation, there's a one-to-one match for every dollar you donate. I'm pleased to report that we have donations from 47 states, the Northern Mariana Islands, and several countries from around the world. Friends, right now, if you are in India listening, please go to constitutioncenter.org/we the people and make a donation of any amount, $5, $10 or more, to show your support for the great programming that you're about to hear today. We've got a bunch of wonderful programs coming up in February. On February 3rd, Adam Liptak of the New York Times, Nadine Strossen of New York Law School, and lawyer Robert Korn-Revere will talk about efforts to censor unpopular speech throughout US history. On February 9th, Gary Kasparov, chairman of the Human Rights Foundation, Judge Claudio Escobar, the Guatemalan whistleblower, Robert George and Kim Lane Shepley of Princeton will examine the rule of law and constitutional systems around the world. That's with the Renewed Democracy Initiative and the SNF Padilla program. And on February 15th, we have three great election law experts, Ned Foley, Michael Morley, and Don Teal, to discuss the merits of recent proposals to reform our electoral process. Check out other programs at constitutioncenter.org. We'll take your questions throughout the show to the degree that I can, so please put them in the Q&A box. And I want to say how grateful I am for our partnership with the Vidhi Centre for Legal Policy in co-hosting this program and making it possible. And now it is a great pleasure to introduce our panel, a dream team of international experts on US and Indian constitutionalism. Arvind P. Datar is senior advocate with decades of practice at the Madras High Court and the Supreme Court of India. He's the author of several books, including the commentary on the Constitution of India, and is the founding trustee of the Palkiva Foundation. Menaka Guruswamy is senior advocate at the Supreme Court of India. She has worked with Mr. Datar to overturn Section 377 of the Indian Penal Code that criminalized same-sex relations. She was a Rhodes Scholar at Oxford and a Gammon Fellow at Harvard, and has been a visiting faculty member at Yale and NYU. Her most recent publications include Founding Moments in Constitutionalism. And Tom Ginsburg is Leo Spitz Professor of International Law at the University of Chicago Law School. He is the author of several books, several of which we have had the privilege of discussing at National Constitution Center programs, including How to Save a Constitutional Democracy with Aziz Hook, as well as Judicial Review and New Democracies, Democracies in International Law, and Judicial Reputation. He currently co-directs the Comparative Constitutions Project, which is a wonderful effort funded by the National Science Foundation to gather and analyze the constitutions of all independent nation states since 1789. Thank you so much for joining us, Arvind Datar, Menaka Guruswamy, and Tom Ginsburg. Let's begin, let's set the stage with a concrete example to help us understand the similarities and differences between US and Indian constitutionalism. The Indian Supreme Court, not long ago, issued an important decision involving the right to privacy. And each of you has written about this important decision, including Menaka Guruswamy. You wrote an op-ed in the New York Times about the privacy decision, where you talked about the ruling which envisioned a right to privacy flowing through other crucial rights like equality, dignity, life, expression, association, and speech. Tell us, Menaka Guruswamy, about this important decision, which was issued in 2017. What was the constitutional foundation of it, and how is it similar and different to important privacy decisions of the US Supreme Court? Sorry, I think you're muted.
Thank you, Jeff. Thanks for having me. Wonderful to be here at the National Constitution Center. So the decision is named for K.S. Puttaswamy, who's a 91-year-old retired judge. And he, along with 22 other petitioners, challenged the constitutionality of our kind of like a data bank that we have, which is called Aadhaar in India. Long journey, and the Supreme Court, sitting in a large panel of judges, really gave a series of judgments, which is kind of our equivalent of Brown versus Board of Education, because it's that seminal, that critical, both as a constitutional decision as well as a decision that influences social fabric. What does the Supreme Court say? The Supreme Court says that in the right to privacy, you have the ability to seclude yourself. You have a right to freedom of choice in terms of food, in terms of dress, in terms of sexual orientation, in terms of ideology, what you believe in. I think importantly, there's just beautiful language in the decision, because the decision says things that, like it says the purpose of elevating certain rights is to insulate their exercise from the disdain of majorities, whether legislative or popular. And I think it's kind of sentiment such as that, judicial wisdom such as that really has raised this decision to a different level, because it sets itself up, it sets the court up really as the arbiter of what we call constitutional morality, which may be quite different from social morality or popular morality or morality of the state or the government of the time. So it's an extraordinary decision because the court also is introspective in the decision. It kind of criticizes itself for its previous decisions, where it upheld, for instance, the criminalization of homosexuality. So it's really quite astonishing. It's astonishing for its width, because the judges navigate issues like, lack of reproductive choices, or telephone tapping, or forced feeding. So it's quite extraordinary for both constitutionally, the effect it's had and it will continue to have on individual rights, individual freedoms, be that against the state or be that within a community. And it's extraordinary because I think with it has become the foundation for many new freedoms that will be mapped onto this constitution.
Fascinating. Thank you so much for that wonderful introduction to the decision. Let me ask you, Arvind Datar, to tell us more about the text that the court relied on, which included Article 21. One of our questioners, Sarah Evans, says she'd love to hear all of your views on Article 21 and the substantive right to life and its relation to human dignity. That right to life was read to include a right to privacy in the 2017 decision. So maybe tell us about the text of Article 21 and how its interpretation is similar and different to the Due Process Clause and Equal Protection Clause, where the US Supreme Court has found rights of privacy and dignity.
Yes, thank you, Dr. Rosen, for inviting me. And I have very pleasant memories of visiting the National Constitution Center. And I still remember the wonderful lecture we heard there in the small amphitheater that you have inside the center. Now, on the law of privacy, as Menaka said, it was the main petitioner was a retired 91-year-old judge. But the entire case came by a completely unexpected turn of events. As she said, you got the social security number. The government introduced what is called the Aadhaar card. That is, you have a card, and under the act, you are entitled for basic amenities like a ration card or cooking gas for poor people and so on. So once you produce that card, you could get entitled for these welfare benefits. But the government started expanding this card, saying that if you want to file your income tax return, you give the Aadhaar card. You want a school admission, you produce the Aadhaar card. And then we had no idea where the data was being recorded, how it was being used. So in the course of the arguments, we raised the point. I was appearing for one of the petitioners. We raised the point that, look, it's violating our right to privacy. I mean, what are you doing with our data? How do we know what's happening? So the then Attorney General, he said that our constitution does not recognize a right to privacy. And it so happened that there was a judgment of 1954 where a bench of 6 judges held that India doesn't recognize a law of right to privacy. And then there was a bench of 8 judges in 1964, 10 years later, which again reiterated that there's no law, no fundamental right to privacy under the Indian Constitution. Unlike what you have in the Fourth Amendment, where you say that all people will be safe and secure in their homes. I don't know the exact language, but I think it's the Fourth Amendment, which says that you're entitled to be safe and secure in your home and so on. So now the Supreme Court was faced with a bench of 6 judges, a bench of 8 judges. As you know, the Indian Supreme Court doesn't sit en banc, they sit in different benches. So the Supreme Court said, look, this is an important point. Why do you say we don't have the right to privacy? It's about time we tested this proposition. And then they constitute a bench of 9 judges. And there was a wonderful dissenting opinion of a judge in the 8 judges bench, which said that right to privacy is there. He did refer to a number of US cases like Munn versus Illinois, Wolf versus Colorado, and various other cases, and said that a man's home is absolutely, it has to be protected. And that was a case of surveillance where the police could ask you to report to the police station. They could come to your house and knock at midnight. He says then the entire country is a prison if there's no right to privacy. And that's how it went to 9 judges. And then, as you see, as I got the law report, the Supreme Court considered 256 judgments of the Indian Supreme Court and a large number of judgments of the US court. And then they held the right to privacy. Now, one question the judges asked us, India has Part 3 of the Constitution, which contains fundamental rights. It starts with Article 12 and ends with Article 36. Now, we have the right to equality under 14. As you put it, Article 21 is the right to life and liberty. We have the freedom of speech, right to religion, etc. 19, 24, 25, and so on. So they asked the question, where will you put this right to privacy? There is no right to privacy, yes. If you're going to read it into, does it form part of what they call the silences of the Constitution? Is it going to be in the interstices of the Constitution? Where do you put it in? Is it going to be in the right to equality, right to life and liberty, and so on? And then they said that there's a concept of core rights, and there's a penumbra around the core rights. And finally, the Supreme Court said the right to privacy cannot be located in any one particular right. And most significantly, they said it permeates through the entire chapter on fundamental rights. Right to privacy is inherent in all the fundamental rights of the Constitution. And finally, they said that you have 3 rights of privacy. They have delineated them. One is physical privacy, privacy of your body, protection, informational privacy, and decisional autonomy. As Menaka said, your right to your career, right to choose your partner, and so on. So these were the 3 rights they recognized. And this has become perhaps one of the most important judgments in recent times, where we didn't have a right of privacy as recognized by the Supreme Court. But almost 50 years later, the Supreme Court itself overturned all these judgments and said, we have a fundamental right to privacy, though not written. It is implied in the entire chapter on fundamental rights. It's a very fascinating judgment. And I must say that we did take a lot of advantage of the US Supreme Court judgments, the wiretapping case in Katz versus United States, and so on and so forth. There's no time, but we did a lot of research into the US law, and it was very useful. The famous sentence of a judge who said the right to be left alone, and so on. Yes. I think it was Brandeis who said that, Louis Brandeis who said that. Yes.
It was indeed. Justice Brandeis is a great favorite of the Constitution Center, and it's wonderful that the Indian Supreme Court invoked him, as well as US judgments like Mapp and Katz, as well as you've both written in your scholarship, US constitutional scholars such as Lawrence Tribe and Mark Tushnet. Now, Tom Ginsburg, as I listened to your wonderful colleagues, this landmark privacy decision seems to have embraced the methodology of Griswold versus Connecticut and Roe v. Wade, a kind of penumbral reasoning, as we just heard, that invokes different sources to find a fundamental right that has textual grounding in different places, but is not perhaps originally intended by the Constitution makers. This suggests that the Indian Supreme Court is quite strong in its ability to make judgments like this. And you've written in Judicial Reputation, a comparative theory, that judges in South Asia are among the most respected figures in government. The judges in India have headed the press council, which serves as a press watchdog. and that the Indian Supreme Court is quite strong and respected because of the status of its judges. So give us a sense, if you could, of how the Indian Supreme Court operates in comparative perspective. Is it a strong constitutional court compared to others? And how would you situate it among the constitutional courts of the world?
Thanks so much, Jeff. And before I begin, let me just say what an honor it is to be here with these two super lawyers. For those who are not familiar with India, these are really two of the best lawyers in the entire country. So it's a real honor for me. Yes, I mean, Arvind Datar was mentioning that the right to privacy was grounded in this kind of penumbral right. And Jeff rightly points out that sounds very much like very famous 1965 case of Griswold v. Connecticut, which is kind of the foundation doctrinally for Roe v. Wade. And of course, this is very controversial in the United States, right? It's not actually written in the Constitution. We have this very textualist Supreme Court now. And many people think, in fact, Roe is at grave risk this very term in the case of Whole Women's Health Collective versus Jackson. So, it's really controversial here. And I guess in response to Jeff's question, I'd say it's not so controversial in India because the Supreme Court has established itself as just one of the major institutions of the country. And it has done so using precisely this methodology of, I wouldn't say inventing, but building space for itself beyond the written text of the Constitution. And actually, I'll just highlight two institutional features of the Indian Supreme Court that make it so powerful. So one of those is that the courts, and all courts in India, are basically self-replicating. The president of India appoints the judges, but must do so, the judges say, on the basis of a recommendation from the collegium, which is the Supreme Court gets five most senior judges. And so that means you don't have the same level of politicized appointments. The Supreme Court is fairly autonomous in that sense. It's able to remain somewhat insulated from the daily grind of politics because it's self-appointing. And that's not written anywhere in the Indian Constitution. That's something the judges have invented.
Very true.
Similarly, the Indian Supreme Court has expanded access to itself. Whereas our Supreme Court is always very concerned with standing issues and trying to get the narrowest possible grounds and really, shut out a lot of cases. The Indian Supreme Court, very famously in the 1980s, created a category of public interest litigation, where if you are trying to make a claim based on a fundamental right, you basically just write something on a piece of paper and send it to the court, and they may hear the case. And so they've been very open, whereas our Supreme Court's been very pinched, I suppose, in the access to the public. So that's those two things, which are, again, not written in the Constitution, have made it a really central institution. I'll just say that courts in South Asia, including the Indian Supreme Court, will sometimes take on cases without even a formal claim. It's a suo motu jurisdiction is what it's called. And so you'll see we just think this is a social problem. We're going to go and we're going to order some institution to do something about it. So quite activist, and generally speaking, from my perspective, quite respected. So it's quite almost a very nice counterpoint with the US Supreme Court, which also lacks a textual basis, but hasn't, necessarily, it's done different things with that in trying to build up its power.
Thank you so much for that wonderful comparison of the US and the Indian Supreme Court. All right, you are indeed super lawyers, Menaka, Guruswamy, and Arvind Datar. And Menaka, if I may, I'm going to ask you to share with our audience as concisely as you can the kind of founding story of the Indian Supreme Court. You have a wonderful article which describes how the court identifies not only negative liberties, but also positive ones. The preamble talks about we, the people of India, having resolved to constitute India into a sovereign, socialist, secular, democratic republic that is secure justice, social, economic, and political, is a kind of rights articulator. But it's a big and important story about how this court, the Constitution adopted in 1950, gave rise to such a powerful court. And you've also noted that the rise of the court is connected to the rise of the ruling political party in India, and that the court and the parliament have worked in tandem. So if you could tell us the story of how the Indian Supreme Court, interpreting the Indian Constitution, came to be the powerful institution that it is today.
So you're right, Jeff. India's constitution is adopted in 1950. The precursor to the Indian Supreme Court was, in fact, the federal court. India's history includes that of colonization. The British colonized us for 200 years, culminates towards the end of their rule. The last 20 years or so, we have a federal court. And that federal court continued after independence, before the Constitution was adopted, and then the Supreme Court came to be. When India's constitution was being written, obviously the framers of this constitution, many of whom had served time in prison and had kind of fought against the British, were skeptical of courts and judges, obviously, right? Because they had been imprisoned by many judges when India was a colony. So there's this wonderful line in the Constituent Assembly debates where one of the members is saying to the other, well, we can't expect much from judges in the Supreme Court. And Prime Minister Nehru responds by saying that, well, as long as they don't get in the way of this country that we're going to build. Fast forward, we're in 2017, you've heard about the privacy judgment, but the court has really become a people's court. And Tom Ginsburg has written about this, that when you open up access, that's how you sort of, become, or you take upon yourself a role of a muscular court, which is going to wade into political issues, which is going to create rights, which is going to hear everyone, which is going to set the terms of constitutionalism, if you will, in a country, not just the constitutional text and interpreting the constitutional text, but setting the terms of this constitutional conversation in a country of 1.7 billion. We're diverse, we have different opinions, we're from different religions, different castes, different orientations. And we're really a people who, have a lot of opinions, and there are lots of movements. So imagine this court, right? And it's very different in terms of texture and in terms of its institutional reality from SCOTUS, from the Supreme Court of the United States, which in a year will hear anything between 20 to 60 cases a year. India's Supreme Court will dispose of, on average, between 50 to 70,000 cases every year. So it's more similar to Brazil's top court. It doesn't sit en banc, as Tom has already told you. So at present, we have 34 positions in the court. These judges will sit in panels of 2, 3, 5, 7, bigger if you have something as critical and seminal as the privacy judgment. But they hear all kinds of cases. And this is the burden of being an Indian Supreme Court judge, right? Or a High Court judge. You will hear everything from a service law claim to a big constitutional challenge in the same day. Mr. Datar and I were in court in different cases today, just today, right, in virtual court. I had an arbitration appeal. He had, I'm sure, a very important case. And the same day, the court is also hearing complex commercial cases. Other panels are hearing constitutional law challenges to a tax. All of this is happening in one day. This is the docket of the average judge, right, who is servicing a clientele of 1.7 billion people, while also saying at the same time that I will not be governed by social or popular morality. I will be governed by the values of this constitution. And it does take, it's not just that you expect independence and courage, but you also expect diligence, because it is also a huge burden to navigate the spectrum of cases where you have both original jurisdiction and appellate jurisdiction. So you can go to the Supreme Court in the first instance, or you can go to the Supreme Court on appeal from the various high courts. And that is quite different from the American Supreme Court, which decides to grant cert and which decides to hear a small selection of highly important cases. So you don't have unfettered access to the court. And when courts allow themselves to have unfettered access, sometimes hear cases suo moto, then they're also saying, we are going to wade into this business of building a country. And that is what the Supreme Court has done. Sometimes it gets it right, and sometimes it gets it wrong. Sometimes it's deeply introspective. It goes back and corrects its mistakes, and it is, open to doing that. And I think that's what distinguishes it. It's unique in South Asia, and it's unique, and Tom will know this. It is unique, but because you have had one constitution from 1950 to now. We celebrate Republic Day tomorrow. It's a big day. I think for me, it's my favorite day of the year. It's the day the Constitution of India was adopted. And it's a big day. This is the constitution that gave Arvind, Datar and me the language to argue against criminalization of homosexuality. It's the same constitution that gives us the language to argue commercial cases, the language to argue social economic rights cases. It's been one uninterrupted constitution. Tom knows that's pretty rare. Tom's work will show you that the average constitution would last 16 years, Tom. It's like being a teenager and then you're out, But India's constitution will turn, a wise 75 soonish. It's endured much like America's has, and it caters to and services very different constituencies. That's the point. And it does so because these judges interpret for this vast, diverse, tumultuous country, which is also having a major moment like your country is, with democracy and democratic constitutionalism. These are important political moments in the United States, as is in India. I mean, I noted, Jeff, that the two voting right bills didn't clear the Senate. You've had this, really interesting vaccine mandate decision, twin decisions coming out of the Supreme Court. These are pandemic era challenges that SCOTUS is facing. Similarly, India's Supreme Court is facing pandemic era challenges. And that's what great courts do. They endure crisis, but they keep the terms of the constitutional conversation going. And the Supreme Court has done in India a very good job of that.
Thank you for that inspiring intervention. It is great that January 26th is your favorite day, Constitution Day at the National Constitution Center. Our favorite day is September 17th, so we will look forward to celebrating with you tomorrow. And as you say, the central role of both of our courts in these challenging times is crucial to understand. Thanks for that phenomenal introduction. Arvind, Datar, our friend Colin Thibault asked the basic question: what are some major differences between the US and Indian Constitution? And can you give us a sense of the fundamental rights in the Indian Constitution versus the US Bill of Rights? How do they compare? And also this important question of how politics affect judicial independence in India.
Yeah, well, it's a long question. I'll try to pack as much as I can in a few minutes. Well, the first important difference is the length. India is perhaps the longest constitution in the world. And as Menaka pointed out, that our constitution was not a completely freshly drafted document. I think US students will know that we had the Government of India Act of 1935, where for the first time you had the concept of a federal government and a provincial government. And you had the union list and the state list and so on, which is basically patterned on the Canadian Constitution. So when the Constituent Assembly was formed to create a Constitution of India, there are two choices: either to have a short constitution like the US Constitution, where the terms are very broad, simple, broad terms, and you leave it to the judges to interpret it, or you have a long, detailed constitution, which is a very lengthy constitution, but then provides for every possible thing in terms of governance. And Dr. Ambedkar, who was the president of the assembly and was called one of the founding fathers of the constitution, he was criticized for adopting a large, long constitution. They said that, look, this is a huge constitution. A constitution must just be a few articles. Here we got a whole forest. That was the criticism laid on at that point of time. And he made an outstanding speech, which is about 11 pages in the Constituent Assembly debates. And I think all of you, if I can share with you, it'll be nice. He says that, look, India is a nascent democracy. As Menaka said, we have different castes, different religions. People don't know that when we became independent, we had 555 princely states, 555 princely states who were sovereign in their own right. They were as independent as the US or India. They all got together. They were integrated into one long country. So there were different religions, different race, different official languages. So he said that, look, we don't have what they call the UK model of constitutional conventions, where they have got the House of Commons for 300, 400 years. They've got basic conventions. They may not have a written constitution, but they got everything in convention, which are followed. So he called that as constitutional morality, adopting the words of Professor Dicey, and he justified the long constitution. So to my friend, I'll say the first thing is our length. Our constitution contains several chapters. We have basically one chapter on citizenship. Then we have, as you write, the most important chapter on fundamental rights, where fundamental rights was not there in the Government of India Act. Two important chapters were added. One was on fundamental rights and one was on directive principles of state policy. So fundamental rights are the rights given to citizens and people. Some rights are only for citizens. Some rights are for citizens and persons. So Jeff, if you come to India, as a citizen, you don't have the right of freedom of speech, but you have the right to equality, because Article 14 applies to persons, but freedom of speech applies to citizens. So there's a distinction between some rights given to citizens, some rights given to persons. Then these rights have been made very, very clear. You have the right to equality, and then you have exceptions to that right. You have right to equality, but 15 and 16 enables you to make affirmative action. You can make quotas for backward classes, socially, educationally backward classes. Then we have the 19, which contains the 7 freedoms: free speech and expression, right to form associations, to travel throughout the country, to practice, propagate religion, to carry on business. So these are the 7 freedoms in Article 19. Then 21 is the right to life and liberty. We had the emergency where fundamental rights were suspended. So after the emergency, we had amended the constitution and said that no matter what happens, emergency or no emergency, the right to life and liberty cannot be touched at all. So that's completely untouchable. You can't touch the right to life and liberty. No court can amend it. So we got that particular provision. Then we have got directive principles of state policy. And then we have the various articles pertaining to the central government, the president, the vice president, the Supreme Court, similar provisions for the states. Then you have the Election Commission of India, that's in the Constitution. You have the Auditor General of India, that's in the Constitution. Then you have commissions for backward classes, for scheduled castes, that's again in the Constitution. So we have all these provisions in the Constitution, which ultimately goes on to almost 400 articles and 10 schedules. So it's a massive document, but I think it's a wonderful document. And as Menaka said, I share her sentiments about the Indian Supreme Court. Somebody rightly put it, it is not the Supreme Court of India, but it's the Supreme Court for India. And it was this institution which has kept and preserved democracy. And one most important thing, which I'll tell the gentleman who asked the question. In 1973, we had what I call the golden moment of our constitution, where they delivered a judgment by a wafer-thin majority of 7:6. And they said that Parliament can amend the constitution, but they cannot alter its basic structure. What is basic structure again was left undecided. They said the Supreme Court will decide what basic structure is. It's almost like a Marbury versus Madison moment for India, where they said that the basic structure of the constitution cannot be altered. Now, what is basic structure? Later, Supreme Court has said secular nature of the country. Tomorrow, they can't make the country into a Christian state or a Muslim state or a Hindu state. It's a secular country. The Republican form of government is part of basic structure. The right to equality is part of basic structure. So we have got the concept of basic structure, which again is not there in the constitution, but has been read into it like privacy. And this is what the Israeli author Yanni Rosnev calls declaring an unconstitutional constitutional amendment. So a constitutional amendment which alters the basic structure is an unconstitutional amendment. Recently, I appeared in the case for the National Judicial Appointments Commission. The Supreme Court struck it down, saying that this power of changing the appointment of judges is completely unconstitutional. So these are the basic differences with the US Constitution. But I must thank the US Constitution for giving us so many new concepts. The right to privacy, the due process in Article 14, then you have the human dignity from the 8th Amendment and so on and so forth. So I must tell the audience that we have borrowed very heavily from the US Constitution in many, many important cases.
That is so fascinating. Thank you for sharing all of that, for that central idea that there could be an unconstitutional constitutional amendment, not an idea that the US Constitution has explicitly countenanced, although there have been some who have suggested that a constitutional amendment that violated natural law might be unconstitutional. That's an exotic view in the US, but in India, it's been embraced. And that, as you describe it, makes the Indian Supreme Court a central actor against what Tom Ginsburg, you have called democratic backsliding. And in your important work, Tom Ginsburg, you've described how democracies can suffer near fatal deterioration in the quality of their democratic institutions, and that constitutional courts can provide a backstop against that effort. You've given an example like Colombia in 2010, showing how a constitutional court can play a role in protecting rule of law norms in the face of a civil war. So tell us, Tom Ginsburg, about the Indian Supreme Court and democratic backsliding and how it plays a central role in protecting fundamental rule of law values in the face of threats.
Terrific. And Mr. Datar actually, was just touching on this in a way, and most Americans don't realize the big crisis that Indian democracy was facing in the 1970s when Indira Gandhi declared this emergency sort of spuriously and was trying to take over the political system. What happened? That's kind of a case of a near miss, is what Professor Huck and I call it, when democracy looks like it's about to fall apart and then something happens. And what happened is that, the opposition got together and they ran an election and they won, surprising. And one of the points that Professor Huck and I in our article make in regard to this is that when democracy is saved in these circumstances, it is often institutions which are not themselves democratically legitimated that play the critical role. So in that case, it was the Supreme Court saying, wait a minute, we have this doctrine of unconstitutional constitutional amendments. It was also the Election Commission, right, which was running, operated, and it's really quite an amazing thing, an Indian election, an election with a billion something people participating, requires an incredible bureaucracy and incredibly effective, institution that is not democratically legitimated. And that's what saved the day. And when you look in country after country, you see this. And so I think that's one of the lessons we can take. And I think it was true after January 6th here in the United States that you had, well, first of all, in November 2020, you had, tens of thousands of local electoral officials, sometimes, very faceless, right, who ended up making sure votes were counted, secretaries of state, military that did not intervene and indicated it would not, and judges who upheld the rule of law and rejected, basically spurious claims by the Trump campaign in that case. So we were also saved by non-democratically legitimated institutions. Now, I think India is really important in the global history of this phenomenon because not only was that an important early case, but also this doctrine which Mr. Datar was talking about, unconstitutional constitutional amendments, turns out to be a really important weapon, and it's spread all over the world. It's been borrowed by many, many constitutional courts. And in fact, as we sit here, there's a really important case going on in Kenya where this is precisely at issue. Basically, what's happening is the Kenyan political elites are trying to kind of cartelize the political system so that they'll just be in power for it. And they're doing it, in ways that appear on their surface to be democratic. And the court, lower courts, the Court of Appeals and the District Court, High Court said, wait a minute, if we let you pass this constitutional amendment, it's procedurally legitimate. But if we let that happen, you're going to have total control over the system. And our democracy won't, in fact, be a democracy. There won't be substantive possibility of losing power. We see this, of course, in some American states. What's remarkable is that Kenya, borrowing from India, the courts may end up disallowing that. Now, our Supreme Court doesn't have such a doctrine, but we do, at least at the state level, have, of course, the national constitution to make sure that there isn't that kind of lockup at the states. So it's just a really important doctrine, a really one that I think is going to be spreading in many other countries around the world in order to, if and where democracy is to survive.
Fascinating to learn about this doctrine of unconstitutional and constitutional amendments spreading in Kenya and embraced by other countries like India and as a central protection against democratic backsliding. Dr. Guruswamy, tell us, if you would, about the values underlying the US and Indian constitutions. Bonnie Zedek asks, what constitutions has the Indian Constitution taken inspiration from? Did the US Constitution and Declaration of Independence influence the Indian Constitution, which has a strong equality clause, or was the Indian experience in equality central because of the anti-colonial struggles out of which the Indian Constitution grew? And then connect that, if you would, to current cases before the Indian Supreme Court involving race and caste. The US Supreme Court just yesterday agreed to take up what may be the most important affirmative action case of a generation, and the Indian Supreme Court has decided important affirmative action cases involving race and caste. Give us a sense of what the court has decided and what sort of race issues and caste issues are on the horizon in India.
Thank you. Thanks for that. That's a great set of questions, Jeff. So I think, we have to understand that equality as it's practiced constitutionally in India and the United States is quite different in terms of constitutional doctrine, right? And I've said this before, the text of constitutions are interesting and they influence doctrinal development, but you can often have identical texts and very different conclusions, very different interpretations. So, India's commitment to equality is really one of substantive equality, which means that, it does take into account historical disadvantage, historical discrimination. So caste as a marker in India, the constitutional text initially provided for special provisions for, heavily historically discriminated castes of people, what we call scheduled castes, scheduled tribes. That has, from the original constitutional document been expanded. You now have reservations, as we call it, which is similar to, but also slightly different from affirmative action, right? So you have reservation of seats in, public institutions, educational institutions, political constituencies for scheduled castes, scheduled tribes, and other backward classes, which is, in fact, a majority of the population often. So the development of, what started out from the text and the development of that doctrine and that implementation is actually secured by the Supreme Court. So the idea being that we do take historical disadvantage into account and then we make reparations. So our substantive equality doctrine is one that actually makes reparations. One can contrast that with the treatment of race in American constitutionalism. So slavery is abolished, of course, but no reparations are made. I think, my friend Catherine Franke has a great book out called, Reparations, that you ought to make reparations for slavery to African-American people. So I think it's a formal equality concept. It treats, X and Y alike. It would treat Tom and me alike, which is fine. But constitutionally, where in India you take historical discrimination into account, in America you pretty much don't. Like you said, there are very important cases coming up which will test affirmative action as its policies and as it's practiced in elite institutions, educational institutions in America. So it's going to be interesting to see how the court rules. Now, the court is also interestingly divided in the United States. You have Republican appointed judges who often will rule a certain way, and you have Democrat administration appointed judges who will often rule somewhat differently, what you call the conservative and liberal. And right now you have 6 conservatives to 3 liberal judges. So that will have some bearing. But be that as it may, you do have very different doctrines in terms of commitments to equality. What is that threshold, and how do you look back into history, which I would argue shape your present opportunities, or do you not? So race and caste is treated quite differently and provides an insight into how these equality doctrines in the world's oldest constitutional democracy and the world's largest constitutional democracy as it's practiced.
Fascinating. Thank you so much for that. Arvind Datar, your thoughts about the affirmative action cases, because you know them so well and the contrast is interesting. There was the 2005 Shania decision, where the court adopted the minority view in Gratz versus Bollinger and struck down affirmative action by a state legislature, concluding that once the scheduled casts are included in the lists, then any division of them would amount to tinkering with the presidential list. Help us unpack that. Fascinating. And also tell us about the affirmative action cases on the docket. And then there are several questions in the chat about cases coming up. Mr. Jatan Gandhi asks you, Arvind Datar, does India need to borrow from the US the ethos of the First Amendment? It was so fascinating to learn from you that free speech rights only go to citizens, not all persons. Do you think they should be expanded? And then put on the table, if you will, what you think are the most significant constitutional cases on the horizon for the Indian Supreme Court.
Yes. There are three parts to your question. One is about the affirmative action. The Constitution said that there could be reservation. You can just take affirmative action as synonymous with reservation for our discussion. The Constitution said that you could make reservation for socially and educationally backward classes of citizens. It never used the word caste. As Menaka said, she talked to race and caste. The Constitution never uses the word caste. It so happened for political reasons. There was a commission formed in 1950 and again in 1970, which had gone into what are the backward castes in India. And so they identified a certain number of castes on certain parameters as backward castes. The government made a reservation. Now, under our constitution, there's already a reservation for scheduled castes and scheduled tribes. Scheduled castes are those people who were unfortunately called the untouchables in the days of Mahatma Gandhi, and then we abolished the untouchability concept. It's constitutionally prohibited now. So you have scheduled castes, and you have scheduled tribes. India has a large tribal population also in different parts of the country. So scheduled caste and scheduled tribe gets a reservation of 15% and 7.5%. 15 for scheduled castes and 7.5% for scheduled tribes. The government made a reservation of 27.5% for backward classes, because earlier there were some cases on reservations, and then the Supreme Court said that, look, reservations cannot normally cross 50%. There's nothing magic about 50. They just said that, look, you can have affirmative action to the extent of 50%, and merit will play a role in the remaining 50%. So that's called the open category or the open quota, and you got the reserve category, which is the first 50%. One major challenge in what is called the Indira Sawhney case. In fact, she's a lawyer in Delhi. Her name is Indira Sawhney. Now the case takes after her name. So Indira Sawhney case was, could you have reservations on the basis of caste? And the Supreme Court answered in the affirmative. They said that basically in India, very often the caste itself represent backward classes. So they equated caste as equal to class, which some scholars say was a wrong decision. But nevertheless, that has now come to stay. So backward classes, and now they've got backward classes, most backward classes, there's a division, they get 27.5%. So this is the role of affirmative action. Now, recently we did a case in Maharashtra where they tried to add new 16% more for the Maratha community. And I had occasion to appear in the Bombay High Court. I lost there. And when we came to Supreme Court, we succeeded. Supreme Court said that, look, you can't cross the 50% limit. That can't be done by parliamentary legislation. Now, the next important case, which is going to come maybe in May, June, as soon as the pandemic is over, is what is the significance of this 50% limit? Because the government, the ruling party here has amended the constitution, the 103rd amendment to the Constitution of India. And the other difference between what my friend asked was, we have far more amendments than you have. I don't know. I think you have 40 amendments. I'm not very sure. 41 amendments to your constitution.
27.
27. Okay. Okay. Yeah. So we have already come to 103. So 103 amendments to the Constitution. And there they have said that for economically weaker sections, there's going to be a reservation of additional 10%. So you've got 22.5% for scheduled caste, scheduled tribes, 27.5% for backward classes, and 10% for the poorer sections of the communities which belong to the forward community. So among the open category, the non-backward classes has now a quota of 10%. Sorry, it's a bit confusing, but the question before the Supreme Court now is going to be, will it be unconstitutional to make a constitutional provision exceeding 50%? Can you cross the 50% limit? Because the question is, if you can make it 60, why not 70? Where do you draw the line? So that's going to be an interesting question that comes up. But today the affirmative action is you got today a 60% quota system for different reservations for different categories, and that's there we stand on affirmative action. And as soon as the Chief Justice constitutes a bench of 5 or 7 judges, we'll be arguing the case whether we should cross 50% or not. So that's the important question. Yeah. And I think he asked one last question about, I missed that.
There was a question about free speech, but
yes.
Maybe just quickly your thoughts about whether the right should be expanded beyond citizens and whether the US should be a model. That was the question.
No, actually what happened is they've reserved this free speech only for citizens. And the difference between the First Amendment and us is that here the First Amendment is almost absolute, whereas our right to free speech and expression can be regulated. It can be regulated in terms of security of the country, defense of India, and so on and so forth. But I must say that the Supreme Court of India has been very, very, very possessive about this free speech. In a case where they imposed customs duty on newsprint, they told the government reconsider it, because if newspapers become more expensive, the right to free expression is affected. When the government said that for the purpose of quota system, they said papers can't be more than 10 pages. They struck it down. They said you can't fetter free speech. So the Indian Supreme Court has been extremely jealous and possessive about the right of free speech and expression. And the only thing is, whether it should go for all persons, I think it should. Anybody who's staying in India should have a right of free speech and expression. But as of now, it is only for the citizens.
Thank you very much for that. Fascinating on both scores. Thanks for helping us understand the affirmative action and free speech cases. Tom Ginsburg, the last word in this absolutely wonderful discussion will be to you, because we do always end on time. And listening to all that you've heard and drawing on your deep knowledge of comparative constitutionalism, would you say that the Indian Supreme Court is strong and independent among global constitutional courts? And if that is the case, why is it the case? To what would you attribute its independence? Help us understand the Indian Supreme Court's success in the global context.
It's a wonderful way to sum up a lot of what we've heard. And I think we have heard, many examples in which the Supreme Court is being looked to by people in the society to resolve the deepest and most fundamental questions of the day. Of course, the United States Constitution doesn't mention judicial review. And so some people say that's the source of our eternal hand-wringing about the counter-majoritarian difficulty. But this is an explicitly, counter-majoritarian difficulty, which is a court, which is, legitimate and is being called on to decide the major questions of the day. And you don't hear the same kind of discourse. Now, there is a lot of criticism of the court. I don't want to sort of whitewash that, but it tends to be about, a lot of criticism about particular decisions, a lot of criticism about the self-replicating nature of the court, which I referred to before. And I think that is one reason that the court has managed to remain so independent, is that attempts by politicians to manipulate the bench have been put aside and have been rebuffed. And so that's what gives it, a sense that it is, a major institution in society. And of course, it's generating doctrines, as I also said, which have been spreading around the world. The creativity of the court, is renowned, and we've heard many examples. I want to go back actually to one of the very first questions, which was the question about the right to life and how that's been interpreted. And of course, the language is very simple, it's very short, but in fact, that right to life has been a wellspring of different decisions by the Supreme Court. Just one example is the Supreme Court interpreted the right to life to say that there's actually a right to food in India. And I believe it was in one of that line of cases, I could be wrong about the doctrinal basis, ordered every school in India to provide food to kids, which is incredible if you think about it. That's a court implementing a major administrative program, a welfare program, through an order based on the right to life. So, I can't overstate its impact. And that's true in India as well as abroad. Now, I do want to say, the criticisms do mount. And the government of India, of course, which is dominated now for quite a while by the BJP, doesn't see the court as its friend and is in times trying to, have more influence on it to pressure the judges in various ways, and has had some success. And so there's a very active discourse about the optimal level, I suppose, of judicial independence in India. But there's no doubt that as a positive matter, it's a very central institution and a very powerful one and a very independent.
Thank you so much to our wonderful panelists for a comparative constitutional discussion at the highest level. It spreads so much light to compare our different but related constitutional traditions. And I want to share a great quote that my colleague Sam Desai found when President Truman welcomed Prime Minister Nehru, one of the founding fathers of India, to America in 1949. He said, "Destiny willed it that our country should have been discovered in the search for a new route to yours." And this kind of discussion, the similarities and differences between our constitutions, is very much in that spirit. Thanks to the Vidhi Centre for having suggested this great collaboration, and it certainly has whet my appetite for more conversations about the important similarities and differences between the Indian and American constitutions. On behalf of the National Constitution Center, Menaka, Guruswamy, Arvind, Datar, and Tom Ginsburg, thank you so much for a wonderful discussion. And thanks all for joining. Bye.
Thank you. Thank you.